Hi, everyone. We're going to get started in about 5 minutes. I see a couple people are already on, though, so I want to do a quick sound check and make sure that you all can hear me. If you can hear me, could you type into the question box on your computer that you can hear me? That would be really helpful. Thank you. All right, everyone, we're going to go ahead and get started. Thank you so much for joining us today. My name is Kyla Franks. I'm the field director at the Tennessee Justice Center and am here with Gordon Bonnyman from the Tennessee Justice Center as well, who will be debriefing the Texas ruling and the impact that it's had on Tennessee's political landscape and where we go from here. So we're excited to talk to you all more about that. Just so you all know, questions will be answered at the end, but you can feel free to type them in at any point in the question box on your screen. So you just type into your question and we'll get to them at the end. And we're also recording the webinar, and so we'll send out that recording at the end in a follow-up email, as well as the slide deck. So if you feel like you missed anything or you want to share this with other people, we will be sending that recording and the slide deck out to everyone after the webinar. So without any further ado, let's debrief what just happened and what it means for us.
Thanks, Kyla. This is Gordon Bonnyman. I'm a staff attorney at the Tennessee Justice Center. As you probably know, certainly know if you signed up for this webinar, on Friday of last week, a United States District Judge, that's the trial level judge in the federal court system in Fort Worth, Texas, ruled in a case called Texas versus United States, or sometimes it's referred to as the Azar case because the Secretary of Health and Human Services, who's the defendant, is Secretary Azar. The case was brought by 20 states' attorneys general, and I'll talk about it in just a second. But first, let me just go over what we will cover and then move from there. First, explain what the court did, why it did it, and what its significance is legally. And then we're going to talk about its political implications at the national level, its political implications here in Tennessee, and then finally, and most importantly, how we can seize the new opportunities that the decision creates. A theme here that you will be hearing is that although it certainly created challenges and can't be lightly dismissed, it's also created some really exciting political opportunities. So without further ado, let me talk a little bit about the case itself. First, for everyone to know, our Tennessee Attorney General, Herbert Slattery, it brought Tennessee into the case as one of 20 Republican-led states. And the lawsuit was filed in February of this year in Texas. It was carefully shopped to that particular court. No accident that when the 20 attorneys general from 20 states were looking at where they might get the most favorable ruling or treatment, what we lawyers refer to as home cooking, that they thought the best home cooking would be in Fort Worth. And they filed there, and they got a judge who clearly was very open and receptive to their arguments. Their argument was that the entire Affordable Care Act is unconstitutional. Some of you may be thinking, but wait, I think I sat through this movie at least twice, 3 times before, and indeed you did. The Supreme Court has upheld the case before, repeatedly, the first time in the NFIB versus Sebelius, the National Federation of Independent Business. In Sebelius, the one that got a lot of attention because it was the first challenge. And in that case, in 2012, the Supreme Court said that the law was constitutional, except that the provision requiring states to expand their Medicaid programs was too coercive, and although states could be given that option, they couldn't be compelled by Congress to take it. And of course, we've been dealing with the aftermath of that ever since. Tennessee is now one of a rapidly shrinking minority of states that has not expanded Medicaid. After the beginning of the year, there will only be 13 states that have not either already expanded or counting 3 new states, Idaho, Nebraska, and Kansas, that voted in public referenda in November to expand. So the tide of history is rapidly moving against us, and other states that refuse to expand. But that dilemma that we faced as a result of the first Supreme Court ruling, and there were 2 more after that that fended off other types of challenges to the law. What the original decision involved was the individual mandate. You'll recall that the way the ACA works is it makes affordable coverage available to most Americans either through the commercial insurance market, through healthcare.gov, the online federally operated insurance exchange marketplace, and it provides premium tax credits to make it affordable, or in the states that have had the wisdom to do so, it expands coverage through the Medicaid program. And what the NFIB case talked about, and I'm going to mention it here just for a moment because it ties into the Texas case, the court was asked to rule that the individual mandate that everybody who has access to coverage through the law must get it or pay a tax penalty, that that provision was said to be beyond, by the plaintiffs in NFIB, was said to be beyond the authority of Congress to enact. The Supreme Court responded in a narrow majority, headed by Chief Justice Roberts, said that although the Congress might not have that authority under its general ability to regulate interstate commerce, it did have the authority to pass the mandate and related laws as a tax measure, which is very broad. The Constitution confers very broad powers to tax. So that's the backdrop. Then fast forward to this time last year when Congress passed the big Trump administration's initiative on tax cuts. And one of the things that the big tax law did was eliminate the tax penalty that the ACA assessed against people who did not comply with the individual mandate. So in February of this year, our State Attorney General, Herbert Slattery, and 19 other GOP officials from different states filed suit in Fort Worth charging that, well, now that the tax law has been changed to zero out the penalty for people who do not comply with the individual mandate, it is no longer possible to justify the ACA as a taxing measure. In point of fact, they didn't actually eliminate the tax. They just made, or the tax penalty, they just made it zero. So it's still on the books. It could be increased back. That's the kind of distinction that we lawyers love to make much about, just to make normal people irritated and crazy. But anyway, that's what the distinction was that was made, was that they didn't actually eliminate it, they only zeroed it out. And the attorneys general said, well, that eliminates the tax, and therefore the individual mandate is no longer, which of course is no longer being enforced, that once that is gone, because it can only be done through the tax code, then all of the insurance regulations that were dependent upon the individual mandate also fall with it. And significant, that includes the prohibition against discriminating in insurance premiums or writing of insurance based on gender, based on pre-existing medical conditions. And those are by far the most popular parts of the ACA. They're overwhelmingly popular, regardless of political affiliation. So the Republican officials went after those provisions, which is legally defensible, but probably not very politically astute in hindsight. So they challenged these very popular provisions, saying that the tax code that was amendments of last year took away the foundation for the Supreme Court's 2012 NFIB decision upholding the law. They argued that not only was that provision void, but once that was struck down, that was the linchpin. You pull that out, the whole thing collapsed. That was what they argued. Now, when they filed the lawsuit, the Trump administration's Department of Justice, which would normally be counted on to defend a challenge to federal law, filed something saying, well, we don't think the whole thing should collapse, but we will not defend the insurance protections for people with pre-existing conditions. Again, legally defensible, but probably not very politically wise. At that point, 15 states in the District of Columbia, led by California, but also including our neighbors, North Carolina and Kentucky among them, intervened and said, wait, not so fast. We don't want this to go down as some kind of sweetheart deal where the federal government agrees to throw the fight. Let us in and we will defend it. At which point, and I just mentioned this because it's kind of breathtaking, and it's gotten no press at all. In July, Attorney General Slattery and his 19 colleagues all filed a brief in the court in Fort Worth, and to try to shut out the other states that were coming in to defend the law, they said, I tell you what, Judge, we'd still like for you to strike down the whole thing, but if you can't do that or you're hesitant to do that, tell you what we want you to do. Leave those other states out of it, leave them alone so they don't have anything that they can squawk about. That cuts them out of the case. And then what you ought to do is just enjoin the insurance protections for people that live in our states. So in other words, the Attorney General of Tennessee was arguing, let the people in California still have the protection of anti-discrimination laws, protections for people with pre-existing conditions, protections for insurance coverage for women, just take it away from people in Tennessee and the 19 other states. An unusual position, to say the least. As it turned out, the Texas judge, the federal judge in Texas, declined that invitation because he went even farther. He just said, look, I'm going to strike the whole thing down. It's all unconstitutional. I've read it. I agree with the overwhelming weight of scholars, legal scholars, that say it's really a reach. The ruling about insurance protections is defensible. The argument that the whole rest of the ACA and all of its provisions, all of those go out the window as well. And the reason for that is there's a legal doctrine that says courts, when they find a law unconstitutional, are supposed to uphold as much of it as possible. This is all in keeping with the notion of judicial restraint, that they should only excise those parts of the law that are either defective themselves or are so interwoven with defective parts that you can't get rid of the defective part without doing away with it all. Well, I can tell you the Medicaid expansion for one, but many other provisions exist. Medicare changes, for example, exist totally apart from what happens to the insurance mandate. And to say that they all should fall together, it really is a stretch. But that's where we are. Now, significantly, the district court did not enjoin the implementation, simply made a declaration. I find that the law is unconstitutional. Further relief to be determined. And what's been made clear is that he's not going to enjoin the implementation of the law, which would have the immediate effect of knocking tens and not long thereafter hundreds of millions of people out of coverage. Rather than do that, he knows it's going to be appealed, and he's withholding that until it goes up. It'll almost certainly go back to the Supreme Court. Certainly it will go to the Fifth Circuit Court of Appeals, which has jurisdiction over federal courts in Texas and several other states. That's a very conservative circuit, and it may uphold the ruling, but I doubt it. And then it will go to the Supreme Court. I think this is such a sweeping ruling that even if they strike down the pre-existing conditions part, I think other courts will be hesitant to knock the whole thing out. And the good news is that the ACA remains in full effect for now, and it'll probably be at least a year, maybe closer to 2, before we get a ruling from the Supreme Court. And in the meantime, nothing changes in terms of people's actual coverage. So what's at stake in the ruling? It's not just people with pre-existing conditions who could suddenly find themselves unable to get affordable insurance, but all the other provisions, and just some of the more popular ones: insurance tax credits that make coverage affordable, cost-sharing reductions which make insurance affordable for people who buy their coverage through the exchange, Medicaid coverage for 15 million people in those states that have had the good sense to expand coverage. That would go away. Insurance for 2.3 million young adults who get to stay on their parents' coverage up to age 26, which is very important because so many of them are entry-level jobs they're in the jobs in the gig economy that don't provide coverage. But as the advertisement says, but wait, there's more. It would do away with bans on annual and lifetime limits. It would do away with limits on out-of-pocket costs. A ban on insurance discrimination against women would go away, as would the required coverage of essential benefits such as maternity care, hospitalization, pharmacy benefits. Those would no longer have to be provided. And then some people may remember the donut hole, which was a major gap in Medicare's coverage of prescription drugs. And the ACA closed that hole over a period of time. It is to finally close. It shrunk, and it's to finally close next year. But that would go away if the ACA collapses along the lines that the district court in Texas has ruled that it should. And that would affect 3.4 million seniors a year. So we're literally talking about hundreds of millions of Americans being affected directly or indirectly. And that, as you might expect, is sending a tremor through the force at the national level. It's been remarkable that Republicans who have clamored for the elimination of the ACA for literally 8.5, nearly 9 years now, have been downplaying this significantly. Attorney General Slattery, in an unusual version of a victory dance, said something like to the effect of, well, this is not going to have any effect until it's been ruled on appeal, kind of implying that, well, maybe it'll get overruled, so don't worry, which is not usually what people who have just won say. They don't usually say, well, I may yet lose, so don't worry about this. But that's what he's saying. Senator Lamar Alexander said, this is the most far-fetched case I've ever seen, and I don't imagine that the courts will let the lower court ruling stand. So I think that says that Republicans, having just been through a bruising congressional fight in which they lost control of the House, in which health care was the main cudgel that Democratic candidates wielded in those fights, that they're very wary of putting themselves back in a position where it looks like they're jeopardizing Americans' health care coverage. But there's not much that they can do about it. I mean, if this were enjoined, it's difficult to imagine how Congress could fix it in the next 2 years, because we have, as you know, a divided Congress with the House under control of the Democrats, the Senate in control of the Republicans, and of course, President Trump in the White House. So it's unlikely that even minor fixes could get through. And also, probably the Democrats are just fine with it hanging out there as an albatross around the necks of their Republican opponents. They're going to be in no hurry to rescue the Republicans from a political dilemma of their own making. And so that's probably, given the timing with which this will come through the courts, it will either still be pending or it will have just been ruled on. But in any event, as the campaigns for 2020 seats in Congress and the White House move forward, this is going to be a major issue. You're going to hear a lot more about this case and what it means. What about the impact on state healthcare politics? Well, the first reaction after learning of this case was to feel like deja vu all over again and what happened 2 years ago. Many people, I think, will recall that as a result of a lot of great advocacy by people on this call and people across the state, the legislature, which in 2015 had shot down Governor Haslam's Insure Tennessee proposal to use Medicaid expansion money, they were under such pressure that then House Speaker Beth Harwell appointed the three-star task force chaired by Representative Cameron Sexton, including a number of extremely conservative lawmakers. They held hearings around the state, and they came back with an alternative proposal that would have taken 2 years in phased steps, but would have ultimately expanded coverage to everybody that would have been covered under the ACA. And it looked as if there was momentum behind that. Then the 2016 elections occurred. President Trump announced that they were, and the congressional leadership said that the ACA would soon be on in the dustbin of history, and that put an end to any conversations in Tennessee about expanding coverage because, of course, if the ACA went away, the authorization for federal funding for the expansion would go away as well. So when first heard of the decision, there's concern that, oh, well, the reaction will be the same, that our lawmakers will immediately say there's nothing to talk about in terms of Medicaid expansion any longer because, don't you see, this court has held it unconstitutional and it'll inevitably be upheld, and in any event, we don't want to step out there when the outcome of the court case is uncertain. That seemed like the immediate read. And I no doubt we will hear that from some quarters. But again, the muted response of Republican office holders, including even the Attorney General himself, were a sharp, sharp contrast to where we were 2 years ago, where everybody was crowing about the fact that the ACA would go away, and now the Republicans are acting as if they really just want to change the subject and not talk about it at all. The underlying reality, of course, is that the problems for which Medicaid expansion would provide at least a partial answer are still there. Hospitals are still closing. I just saw literally 15 minutes ago a new listing by states of hospital closings, and we remain number one in the country in terms of the rate of closings when you take into account our population, more per capita than any other state, and more in absolute numbers than any state except Texas. We got the substance use disorder epidemic, rising premiums, and of course we've still got 300,000 people who are without coverage who would be covered now had we expanded coverage or adopted Insure Tennessee. So those problems have not gone away, and now we have pre-existing conditions. If you were a Republican strategist, your worst nightmare would be that somebody would go on your team and jeopardize coverage for people with pre-existing conditions. That's 32% of Tennesseans. It is an enormous percentage of Americans nationwide, and it is the hot button of hot buttons around health care. And the way this lawsuit was framed and the way it was prosecuted, actually, that was the bullseye for the Republican plaintiffs, was they were going after the protections against pre-existing protections against discrimination based on pre-existing conditions, which, again, might have been legally clever. It helped them win in the district court at least, but politically not very astute. And at the same day, just hours before the release of the Fort Worth decision, Vanderbilt University released its semi-annual poll in which of likely Tennessee voters, and for the first time in history identified health care as the voters' top concern. So if people were concerned before the Fort Worth decision was announced, they certainly have reason to be concerned now. And of course, we've just been through an election campaign where both parties were doing lots of polling of their own for their candidates and framing their message. And the Republicans know that the one point of their vulnerability was on health care. Now, of course, they're probably thinking, some of them are thinking that, well, that was the main issue that Democratic candidates, Carl Dean for governor, other candidates running for state House or state Senate seats, they ran on Medicaid expansion and they lost. They lost badly. And so that can't be really bothering Tennesseans very much, or they wouldn't have voted that way. Well, I think the answer to that, and I've heard this already from some Republicans that know better, is that the message about how Medicaid expansion is connected to these other issues that they are worried about, and the position of their candidates that they voted for, just kind of hadn't caught up yet. But the concern is that it will, and certainly that it will over the next 2 years. So this is why we think of this as creating a new opportunity that we didn't have before. The Texas ruling, which again is going to be very much in the news going forward, links the fate of Medicaid expansion to the rest of the ACA's popular provisions. And that changes the conversation. The issue is now no longer just about, well, should we do something for somebody else? Most households, one way or the other, can look at the effect of the ACA's elimination and conclude that, hey, I've got a dog in this fight. My coverage is vulnerable. So, how do we make the most of the new environment, make the most of this opportunity? I think the answer, and we've given it some thought here, but certainly, and have had conversations with others, and everybody is welcome to contribute because we're making this up as we go along. But our notion is that we want to keep the same goal, which is Medicaid expansion, to the 300,000 folks who don't have coverage, with all of the benefits that it would bring to a host of other people in rural communities and across the state. But we no longer want to make that our front and center message. So Medicaid expansion, bring it home. Here at TJC, we're planning on muting that message. And instead, taking a cue from some of our colleagues with other organizations that have said, you know, we'd really rather be talking about the problems and not setting ourselves up as having the answer of Medicaid expansion, because we just get knocked down when we say that. People immediately reject that, or at least Republican lawmakers do. So why don't we focus instead on the problems and ask the lawmakers to find the solutions? And we think that's wise. And now that the problems have broadened to include a huge percentage of Tennesseans, we want to broaden the lens to focus on the array of healthcare problems that have catapulted healthcare to the place of top concern of Tennessee voters. And the theory here is that, again, it's the same goal, but a different route to get there. That by making pressure to solve problems strong enough, we can motivate officials to find a way to solve them. And we think that that way is Medicaid expansion. But again, if they can get there without it, go for it. So our messaging is going to focus much more about the problems. And the message, the problems can't wait, and some of you will be, probably most of you will be aware that Governor-elect Bill Lee, his position on health care is he's against Medicaid expansion, and he's going to come up with a 20-year plan to address these problems. And of course, for many, many people who are sick right now, and for hospitals that may close over the next couple of years in rural communities, 20 years is more than a day late and a lot more than $1 short. So our theme, we think, should be problems can't wait. What's your plan for solving them? And to really emphasize things that are quite broad in their appeal. And again, pre-existing conditions is the #1 issue, which is why it's on this slide italicized and in boldface. Pharmaceutical costs, that's fair game because, again, if the ACA goes away, then the Medicare drug benefit is radically reduced. It's not eliminated, but it's radically reduced. Rural health, we already know about the plight of rural hospitals, and of course, if we lose the rural hospital, we lose the doctors, the nursing home, the community drugstore, the nurses, the whole healthcare infrastructure, and we lose jobs and the opportunity to recruit new employers. So that issue is only getting worse. Tragically, the SUD epidemic, the fatalities continue to rise, and although both the legislature and Congress have thrown some money at it, they are far from having curbed the epidemic, much less the deaths from the epidemic. So that's still out there, and it's touching more and more families. And, of course, the issue that got us here to begin with is the 300,000 of our neighbors without insurance, the people in the coverage gap, including 24,000 vets. And we just want to keep banging away at those, but again, probably in something close to that order, just because it broadens the conversation to include many more people that it's difficult for politicians to ignore. We think this is a message for all elected officials. We want them to get the message that when people talk to them about these issues, they're talking to them as healthcare voters. And by that I mean people who will vote based on the healthcare issue. I mean, again, to go back to what just happened in November, at the national level, healthcare voters helped flip the Congress, the House of Representatives. That did not happen at the state level. We know, though, that voters now have those concerns, and they are bound to be magnified as more and more people learn about the implications of this court case that our own Republican state leadership is prosecuting at the potential expense of Tennesseans' health care. So we want to convey that we will vote on the basis of health care. It's that important an issue. Just as Second Amendment enthusiasts say, you know, I care about guns, that's really what I care about the most, and I'm going to vote based on where you are on the Second Amendment. Same with people that are agitated about immigration. The state of Tennessee has very little to do with immigration policy or immigrants, but that doesn't keep Tea Party folks from asking, where do you stand on immigration? And it certainly doesn't keep everybody from local county commissioners on up to the lawmakers in the state capitol from saying, oh, I'm against it, or I'm going to do so-and-so, even though they know they don't have any authority to affect it. So we want to get everybody to declare where they are on solving these very pressing health care concerns of ordinary Tennesseans. And you know, by the way, if you can, we're not picky about how you do it. If you can do it without Medicaid expansion, fine. If you do it with Medicaid expansion, that's fine too. Go for it. What we want is results. What's your plan? Don't just tell us you're against Medicaid expansion. Don't tell us you've got a plan for 20 years from now. Tell us what you're going to do right now. So to talk about a couple of concrete things, we're fired up and hope that you will join us. And Kyle, I'm going to let you talk a little bit about the Witness for Healthcare.
Yes, so we're going to gather in witness the day before the 2019 legislative session starts. So I'm sure you all know, but the Tennessee legislature at the state level only meets from January until April or so every year, not the whole year. So the next session will be starting on January 8th. It's the Tuesday after this witness. And we are going to gather and witness the day before to remind our lawmakers of all the urgent healthcare issues they still have not solved and call on them to address these healthcare issues now. It's really, an important time to get press coverage and to, show a sign of solidarity of us all standing together to say, what is your plan for making sure that everyone in our state is protected, from discrimination against people with pre-existing conditions, or ensuring they have access to affordable health coverage. So we'll be gathering together to bring those stories of people who are impacted by these various health issues in our state, people who've been impacted by rural hospital closings and sharing their stories, people with pre-existing conditions sharing their stories, and bringing these stories to the Capitol in signs and visual representations to show all the various ways that our politicians need to take action. So this will be on Monday, January 7th, as I mentioned, at 11:30 a.m. is when we will gather at McKendree United Methodist, that is downtown Nashville, and then we'll be going to the Tennessee State Capitol. There will be accessible accommodations, transport going to the Capitol if that is necessary for you. We're happy to work with you on that, and we're making provisions for that. There'll be a press conference event there, and then we'll go back to McKendree to debrief and talk about next steps. How do we keep building power? How do we keep making these issues heard and making our voices heard? So please come. It's really important, to invite your friends. So we put the Facebook event on here so you can tell everyone that you know. And it'll be a great way to get fired up for the 2019 legislative session for demanding solutions for our lawmakers.
And let me just add that this was going to be, until the Fort Worth decision, a witness for Medicaid expansion. And as you see now, we broaden the lens dramatically. Again, we do not want this opportunity to go to waste. We think that this is a really important opportunity to let everybody identify with this issue in one way or another, whether it's a Medicare beneficiary concerned about drug costs, or upper middle income family with a college kid that they're worried about their insurance being lost. I mean, we now are no longer just sort of relegated to a corner of the ACA where Republican lawmakers feel that they can safely ignore it and just say we're not for Medicaid expansion. We are shifting the conversation in ways that we think it will be impossible for them to say, I don't really care about your pre-existing conditions, or go talk to somebody else about your drug costs. I think they may say that initially, but I think if we say it loudly enough and persistently enough and get enough other people to do it, they will find it that they just have to engage in that conversation.
Also, take action now. So I would bet to say that everyone on this call either knows someone who has a pre-existing condition, or themselves has a pre-existing condition, or a family member has a pre-existing condition. As Gordon mentioned, this is such a significant portion of the population of the U.S. If that's true, then tell our U.S. representatives and senators to protect our health care. And if you yourself have a pre-existing condition and want to share your story about how the ACA helped you to get coverage, then there's a box on that form that you can check to say that, yes, I want to share my story, and we can work with you on that. Or you can email me. I'll be sending a follow-up email with these slides and the recording. And we just think it's really important that people who were able to get health care coverage with the ACA who weren't able to before are sharing those stories. We can make those connections about, how important the ACA is for so many of us and what is at stake now, and how all of our health care is interlinked, and we should all be fighting for accessible health care for everyone. So sign this, tell your senators to protect our health care, and let me know if you want to share your story. With that, we'll answer any questions that you have. So what you can do to ask a question is on the computer, just go, there'll be a sidebar that says questions, and there's a question box. Just type in your questions, and we will go ahead and get those answered. I'll give you guys just 30 seconds or so to type in your questions. All right, well, I'll send out the recording of this webinar and the slides to everyone. We'll let you go a little bit early so you guys can, finish your Christmas shopping, prepare for the holidays, and we're so glad you joined right before the holiday season. Let me know if you do have any questions, and I'm looking forward to seeing all of you on January 7th. Thank you, guys, and have a great rest of your day.